Since there's been so much discussion about the IP policy, I want to spend 2 minutes speaking about it before I go into the standards issue. I don't think India has seen in the recent past any Prime Minister who mentioned intellectual property 16 times in his different speeches in the last 2 years. That was the context in which the IP think tank was constituted in September of 2014. And the first draft of the IPR policy came out in December 2014. And let me tell you, as part of the think tank, we were not prepared for the volcano of comments, perspectives, views that we got. The members of the think tank, who were 6 of us, we must have spent, I don't think we counted the number of man hours, but at least I remember that during the period January to July of 2015, I spent 50% of my day in court and 50% of my day with the think tank, which is a humongous amount of time. And we received a number of comments, and you would be surprised at the number. Approximately 500 to 600 views and perspectives from almost every country, every trade delegation, every embassy. And I want to add a footnote here that Jericho, which made one of its presentations, and this is a secret between the think tank, was one of the best presentations to the think tank ever. And with these 500 to 600 comments, with 60 to 70 delegation meetings, came the final draft of the IP policy. And then happened the interministerial consultation. And all of us in the think tank submitted the final draft in July, April to July, and we all thought the government had slept after that. Okay? But to our very pleasant surprise, between July to May of 2016, when the final policy was announced, I was invited in July of 2016 to make a presentation in another trade organization as to what I think has happened to the IP policy. And you will all be surprised to note that the IP policy in its published form had in fact not just remained a paper document, but had been implemented in several areas on the ground. And let me just name about 6 to 7 areas. You can all go do your research, and then I will stop talking about the IP policy. The first area, May 2015 budget speech of the finance minister. All global royalties earned from patents registered in India, developed and registered in India. Instead of 35% as the tax, you pay only 10% as tax. So financial incentives. That was the first big recommendation in the IP policy. Including of IP in course curriculum. I'm sure you all heard the Invest India representatives yesterday. It has actually happened on the ground. Expedited patent examination rules, already notified. Recruitment of examiners actually happened. 500 to 600 patent examiners. Startup India, incentives for startups. Mediation in IP. A panel of mediators drawn up, 500 trademark opposition cases referred to mediation. And each of the arbitrate mediators are lawyers with more than 10 years of experience. Facilitators for startups. Most law firms who are practicing in IP have at least 3 to 4 lawyers within their firms who have acted as volunteers to help startups. And I know that several of our colleagues receive emails every day from individuals across the country saying, how do we register this, how do we register that? And this is happening completely pro bono. The government gives 10,000 rupees to the lawyer when the patent is filed, and the government gives another 10,000 rupees when the patent is granted. That's the only incentive. So we are actually seeing action on the ground in the last 1 year on the IP policy. That's it on the IP policy. Please read up on it, and I'm very happy to say that our work has been noticed and it has produced results, and the government has taken it seriously. And now we come to standards. I call today as the day of the third S. We had Sakshi winning the bronze. We had Sindhu winning the silver yesterday. And today I hope we talk about standards, which will hopefully win the gold for India 10 years from now. Okay? Standards are here and are here to stay in India. They are in every product and in every walk of life. We only know of the smartphones. We didn't know about the VCD players, the DVD players. When is the last time that you all played a DVD player or a Blu-ray player and realized, oh my God, I bought it in the US, but it's still working right now. It never used to happen 5 or 10 years ago. You would have to see whether it was a PAL or a CCAM or whatever. So this is the life of standardization. They span products, they span household appliances, smartphones, and this is bound to increase in the future. What is the choice that India has to make today? You know, in 2013, when we were approached by Ericsson to file the first infringement action on an SEP, I could have never imagined such a huge debate 3 years down the line. It's just been 3 years in India. So today we have a choice to make. And what is that choice? That choice is, we should decide if India should be IP compliant in ACPs. Let's say, okay, India says no, we don't want to be IP compliant in ACPs. So then what do? We can have guidelines and laws not to grant patents. The fiasco of the CRI guidelines, we all know it. We could do that. We could have lots of guidelines saying, okay, we shut out patents in this field of technology. We can bring out compulsory licensing provisions for all SEPs. We can expect the IPR policy to have a clause saying all SEPs should be compulsorily licensed. The government should fix a royalty rate, which will ensure that all businesses exit from India. There will be no manufacturing in India and there will be no R&D in India. We have a choice, and this is a choice, and it has to be a conscious and a deliberate choice. If we say no, this is what we need to do. But suppose we say yes, we want to be IP compliant. What do we then do? We have the choice of negotiating, and in a case, we do have the choice of litigating in court. What is the position internationally? There are several patent pools, there are patent owners, there are arguments of hold-ups, there are thousands of patent global agreements which are negotiated between parties, and there are remedies which are available from national courts if there is a disagreement between parties. Rarely they do go into litigation. It's not bad to go into litigation. Sometimes it's good to have some jurisprudence developing. But when we talk about ACPs, there are arguments of royalty stacking, patent hold-ups on one hand, and on the other hand, we also have the problems of unwilling licensees and patent holdouts. So this is the kind of the international position that we have today. One thing we need to keep in mind, all these thousands of patents and their agreements, they are not negotiated patent by patent. They are not negotiated jurisdiction by jurisdiction. They are not negotiated product by product. They are negotiated for multiple patents, multiple owners, multiple portfolios, and on a global basis. Please bear this in mind. What should royalties be based on? The value of technology, that's one view, when it became a standard. Did we do an empirical analysis when the technology was adopted? I don't know. Should it be based on comparable agreements? Possible. Should essentiality of patents be judged? Definitely. What about net balancing royalties and cross licenses? Surely they have to be there. Patent owners are entitled to enter into cross licensing agreements. There is no broad consensus, but I would say it shifts in favor of comparable agreements. The market dynamics, as the economist on our panel said, the market dynamics determines what is the price. This slide is my personal experience. On ACPs, India unfortunately is being bombarded with confusing messages. There is enormous amount of underlying friction happening between ACP and non-ACP owners. And there are a large number of institutions, private bodies, etc., which send out these confusing messages. It defies logic, according to me, if you say that if in normal patents you can grant injunctions, don't grant injunctions in ACPs. So the ACP owner is the sacrificial lamb. He first made the mistake of developing the technology. He then made the mistake of allowing it to be standard. And then he makes the third mistake, I will license it to everybody. And then he sacrifices his statutory rights under patent law. Is that what we want ACP owners to deal with? The statutory rights of patents are not suspended for ACP owners. ACP owners have to honor FRAN, but that doesn't mean they've given up their patent rights. There are no provisions in law which says a patent owner will enjoy exclusive rights, etc., provided in the case of an ACP owner, the above rights are suspended. No, there is no provision in law. Why do we expand FRAN commitments, a mere contractual obligation, to a higher position than a statutory right? Look at the international trends. This is from the IAM magazine. The number of declared ACPs is rising, but there's also a steady increase in the number of declared ACPs which are being subjected to litigation. This is fine because as technologies develop, there is bound to be a lot of friction, and some amount of friction is required for society to progress, as Dr. Ganguly says. Luckily, I'll just show you what India has done. In India, we've just had some ACPs in the area of electronics and most ACPs in the case of smartphones having been litigated. But please see what has happened. Is this what we want? 6 infringement actions filed against 4 Indian handset makers and 2 Chinese handset makers. Please see what they resulted in. 36 cases, including 17 appeals and 5 petitions to the Supreme Court. I'm not counting the countless number of applications that are filed in these cases. These are actual figures. These are not fictional. This model, is it sustainable? From any perspective, it's not. Manpower, costs, time, capital, resources. It's not possible to sustain this litigating model. Some cases have to be litigated. That's understandable. However, what is the solution to this? What have courts done? Courts have been very consistent in their approach in India. Unfortunately or fortunately, the courts have kind of been insulated to this hectic amount of conflicting opinions that are emerging in the media. The courts have primarily done something very logical. There have been orders of injunction if there was a long history of negotiations. Interim deposits of royalty in court have been ordered pending trial. Interim payments of royalty to the owner with cross guarantee by the owner, and securities by the defendant pending trial. And these are the normal remedies that courts grant anywhere in the world for any IP. Why is it different in the case of SCPs? This should be the normal model, and I don't think that anyone can find fault with what the Indian courts have done. The final determination on any ACP case is yet to take place. Hopefully, it should happen quickly. As the Member of Parliament said in the opening session, the government has enacted the Commercial Courts Act, and I can tell you, being on the ground, it is actually making a difference on the ground in litigation. We've had cases where trials have been concluded in less than 4 months in ACP matters. Just 4 months. March to July this year, including witness depositions of about 8 witnesses and costs having been imposed on the defendant for delaying the trial. So the final arguments are yet to commence. So the Commercial Courts Act is making a difference, and hopefully with more resources in the judiciary, we should see quicker results. Let's come to competition law. What has happened on that in India? It's the normal friction between IP and competition. In my view, IP is the exception to competition, but there are overlaps. The first opinion of a court has come that the Patent Act is a special act. There is no repugnancy between the two acts. The CCI, the Competition Commission of India, cannot determine infringement, invalidity, damages, royalty rates, but does have limited jurisdiction in case of abuse of dominance, which I think is one possible view. The final view is yet to be taken. Going forward, so what should India do? In no other country are FRAND rates determined by governments, as one of my co-panelists said, except I know of the Chinese NDRC order. Courts evolve the principles to determine FRAND. Governmental policy cannot determine FRAND and should not determine FRAND. The national IP policy does highlight the need for examining availability of SCPs on FRAND terms. The Delhi High Court's decisions till date are in comport with current judicial and international trends right now. In my view, the culture of negotiation in India has to be developed. That's the first and the most important key element of SCPs. Broad negotiating benchmarks have to be laid out. There is a need to learn from international patent licensing negotiations and how they are conducted, and litigate if there is a serious challenge. There is a change in mindset that is needed. When a notice comes on a patent, please don't say, okay, go challenge it, go file for invalidity. No, there is a possibility. Talk to them, talk to the patent owner. FRAND commitments are meant to protect technology implementers while ensuring patent holders receive an appropriate reward for their investment. It is like paying for a transistor or a capacitor within your product. It's part of the input cost. It's like a raw material. We will not be able to achieve the dreams of Make in India without technology. Digital India, Smart Cities, Startup India. Look at Startup India. Someone just mentioned, I think the professor, just mentioned that there are so many applications which are going to be developed in the next few years by Indian companies. Are we inventing novel hardware there? No, we are not inventing novel hardware. To have a legal requirement that for anything to be patentable requires novel hardware is like asking for the moon in this age of technology. Indian startups will develop better technologies in applications. The change could be very incremental in the hardware, but it could be robust in the way it is implemented, in the technical effect or the technical application. They need patents for protecting their future. What is the point of having all these startups if we can't give them patents and if we can't make them move on the curve? They will be investing so much. If they invest in 10 projects, only one may succeed. And we will ensure that even that one fails if we don't protect their innovation. Every Indian home makes dal. We buy the lentils, we buy the spices, and what's missing here, which I put in, we buy the ghee. In the same way, when we buy the transistors, capacitors, the PC boards, the processors, we need to buy the technology or license the technology. One-sided debates will not foster innovation. Owners of technology should be treated as partners. India is an important market for technology owners, and they will come to India as they already have. Let's benefit from that rather than drive them away, and this, according to me, is our collective responsibility. Thank you very much.